These are clearly legally unusual times and strange times. And it's all accelerating. And for people who are supposed to be impartial, whether that's judges overseeing a case to independent reporters doing their best, just describing these abnormal and troubling realities can itself sound like criticism. If you say, oh, gosh, they're talking about a license to kill innocent people, almost sounds like you're going at them, when really you're just accurately describing what they claim they could do in court 6 months out of an election. The New York trial resumes tomorrow, and I can mention I will be in the courtroom tomorrow. We've been relying on our own team of reporters, and we trade off sometimes, and I'm going to be in that room, and I'll share with you what I see and learn if you tune in tomorrow. But prosecutors will be calling more witnesses this week, both sides gearing up for Michael Cohen. Prosecutors view him as the eyewitness to a campaign crime. The defense lawyers, they think Cohen could help. They brought him up in their opening arguments. They view him and his past as a key to showing jurors some kind of reasonable doubt about the case. If you can't trust Cohen, they argue, then how can you have confidence beyond a reasonable doubt of a crime? New York is the only place where a criminal trial of Trump is on track to finish by the election. So for all the punditry and discussions you may have heard about which case was stronger or who should go first implies there's a second. And as of now, that looks unlikely. D.A. Bragg is the one prosecutor who is actually putting Trump on trial. That's a fact. And he's the only one on track to finish a trial by the election. The Atlanta DA moved more slowly and less effectively. Jack Smith is hitting roadblocks beyond the control of a federal prosecutor, first hobbled by the DOJ's late start, that's his bosses, and then running into this MAGA-friendly roadblock at the Supreme Court just last week. That controversial hearing, which showed Chief Justice Roberts may be presiding over the most obviously partisan court in the modern era. That should be an embarrassment to him, given everything he said about independence, or to justices who care about that, but that might be now a minority of members of this court. Again, I say that as an observation about the way the hearing went, not a criticism just out of the air. Here's a nonpartisan report from the New York Times, which notes the conservatives on the court went in this unexpected direction last week, without precedent, rushing to try to limit whether defendant Trump can be put on trial at all, and putting a thumb on the scale in the timeline to probably delay it past the election. Here's the different trials we have been covering and which may actually turn green or happen. Now, we've reported on those arguments that night at the table. Rachel and our whole team talked through it. There is no precedent for any president in any party having wide immunity just because they once had the job of president. And there's a lot of history on the other side, from Nixon and other eras, and what you've heard from grade school on. Nobody's above the law, right? Nobody means nobody. Or does it? Since Thursday, more legal experts are hitting the obvious partisanship at play here. A court that claims to follow precedent and text is now, and we heard it in the arguments, leaning towards ignoring text entirely. Because remember, it doesn't say anywhere in the text of the Constitution or the Bill of Rights or any of that, it doesn't say anything about having permanent immunity after you leave office. The court's Trump appointees cannot cite any text in the Constitution in that long hand that's supposed to guide us to bail Trump out. They would need something a lot more recent or non-binding. They, I guess, could cite the text of the Monopoly game's get out of jail free card. Those words would apply here, but again, as you may know, Monopoly is just a game. Now, as the Supreme Court slows Trump's trial, the other thing, as we start the week, that we're seeing here is how the independent legal process around the country in states red, purple, and blue continues to find more evidence of 2020 election crimes. These are the kind of stories that would be a huge deal if they broke in 2017 or 2018 or even right after the insurrection in 21. But now, in 2024, as our colleague George Stephanopoulos said, people are numb to this kind of thing, but it's actually a big deal. It is significant, whether you're tired of it or not, right? That doesn't speak to significance. It speaks to your emotional news diet. And I do understand sometimes saying it's a lot to keep track of. But whether you're used to it or not, numb to it or not, it is a big deal that Arizona and Michigan are barreling forward with these cases just in the last week. Evidence there supporting defendant Trump in New York, also being branded an unindicted co-conspirator in those cases while his aides face fresh charges. Even more heat in one of those cases today that we just learned about. A former Trump aide caught up in Michigan prosecutors' new searches for evidence from Google and X involving convicted lawyer Kenneth Chesebro. CNN has that report. We have not independently confirmed it. But as we track all of the plots, most involved Trump and his aides and others willing to help them. Because remember, it takes a lot of people to pursue this many separate plots. I'm not going to read them all out, but there's a bunch of them, roughly 7, to steal an election. So in Arizona alone, it is 18 total people, Republican operatives and aides, charged with the attempted crimes from 2020. That includes people who responded to the Trump campaign's call to pose as electors in states that Biden had won. Now remember, people get in trouble just for lying on their own taxes, just about their own finances, or lying to a bank to take out a loan or start a business. So lying to the federal government and the state government to try to steal an entire national election is a very big deal, legally and substantively, but we're talking law right now. Take the Arizona residents who claimed they were the real electors after Trump had already lost. They are indicted for that fraud that you can see on your screen, charged with crimes of forgery and fraud that they filmed themselves. Here they are signing fraudulent certificates in a place where Trump lost, claiming they were the rightful electors. And again, if all those plots and arrows that I showed you had worked better, had they been a more effective crime spree, these are the people that would have been cited by potentially Mike Pence or a different vice president on the Senate floor on the 6th saying, no, these are the real electors. It matters a lot that in their own state, they are right now criminal defendants, not some jump ball where up is down and the liars claim they represent the people. The Republican Party, though, has not gotten the message. They are promoting some of these very indicted individuals to Republican National Committee posts. The defendants are responsible for their own actions. But those who have spoken out in these plots I'm telling you about, sometimes at the local level, were clearly responding to the prodding and the requests and the talking points of what was left of the Trump campaign. Here's one of them discussing it about 2 years back.
What authority did you find yourself as an elected?
So in unprecedented times, unprecedented action is occurred. There is no case law. There's no precedent that exists as to whether or not an election that is currently being litigated in the courts has due standing, which is why we felt it appropriate to provide Congress and the Vice President with dueling opinions.
If you say it and you pause and you use words like precedent, are you a criminal? Look, what you heard there was false. Now, like everyone else indicted, everyone is presumed innocent, and they'll go through the court process. But there actually is a lot of precedent. And you don't need to actually be a lawyer to cut through some of this. You remember Bush v. Gore. You know what it looks like when there's a closely contested election. Supreme Court hears things when there's really tight races within 100, 500 votes and you have a recount. That wasn't the case. President-elect Biden was the winner, had won by 3 states. The Supreme Court, even with the Trump-friendly appointees that are on there, didn't ever see any evidence that led them to even take a case, let alone hold oral arguments, let alone side with the MAGA conspiracy theory side. So when you hear someone just use a bunch of words to talk about their fraud, right, that's no different legally than if they said, I don't like what the bank did. I'm going to go in there and take the money because I think it's rightfully mine. Yeah, that's not your money. And this wasn't their election to overthrow. So a contrast here tonight, I think, is pretty glaring. The highest judges in the land are minimizing January 6th. They're helping defendant Trump avoid trial, while the evidence in the courts around the nation that I just showed you are actually working. They continue to address these election crimes. 4 different states now indicting the elector fraud. That's 4 more states than, say, 3 years ago. Trump's aides and lawyers face an onslaught of legal consequences that we are tracking. Here's just some of them and some of the different stamps that they've faced. To just give you a brief overview, we're looking at disbarment and penalties and fines and charges. And those who are charged still get a trial and they still are presumed innocent, but that's part of the accountability. And we're also looking at some convictions. In the lower left, we're also looking at some prison in the case of Mr. Navarro and Mr. Bannon awaiting a prison sentence for his conviction, but he is currently out on appeal. As for that lawyer I mentioned, Chesebro, back in the news for the search tonight, he's named as a co-conspirator in the new Arizona case. Again, if you're keeping track, he's one of the individuals who was convicted already in Georgia, admitting fault, just like his fellow disgraced Trump lawyer, Jenna Ellis.
How do you plead to count 15, conspiracy to commit filing false documents in indictment number 23SC188947?
Guilty.
If I knew then what I know now, I would have declined to represent Donald Trump in these post-election challenges. I look back on this whole experience with deep remorse.
Okay. Deep remorse. None of this is easy for anyone going through it, even if they made mistakes. And the process that we have, especially for non-capital offenses, for the vast majority of trials, is to try to give people a chance even when they're being held accountable. That's why judges take testimony even from people before sentencing. Remorse is a start. Accountability is important. And it has actually come to many people in these cases, just not the defendant at the very top. For all the talk about politics or ideology these days, what we learned out of the Supreme Court last week is the majority was fixated on hierarchy and protecting its apparently favored person who was at the very top, the defendant, ex-president running for president again. The court did not raise the same questions or concerns about the convicted aides that you just saw, or how future aides or lawyers or generals or attorneys general would do their difficult jobs with the possible threat of later accountability if they commit blatant crimes. For some reason, that concern was just for Donald Trump. So I tell you, as we start this week, we're living through a time of some accountability for coup enablers at the bottom and in the middle. And there's a bunch of Proud Boys stuck in prison for years. But we're also living through something that got even more clarified and exposed on Thursday. A kind of elite MAGA protection racket within our own government at the very top.